the court to this webinar. I know we're going to be talking about a lot about statutes and Florida statutes. And, I just wanted to preface this. We're all home. I know a lot of us are still home, still working from home, doing a lot of these Zoom webinars. But yesterday we did, and associations in general have been dealing a lot with COVID and COVID restrictions and how we're dealing with our associations. But I just wanted to mention that Governor DeSantis did sign into law yesterday a COVID bill that protects businesses, and associations fall under that category, protects businesses from claims brought by plaintiffs for damages related to COVID, and basically requires any plaintiffs that are bringing claims for COVID against businesses to submit an affidavit signed by a physician attesting that they are fairly certain that the COVID damage was caused by the defendant's negligence. So I'm sure we'll do blogs and articles and probably seminars and webinars on that, but it did happen yesterday. So make sure you get in touch with your counsel to find out more about it. But I just thought I'd mention it off the bat. All right, I'm going to start sharing my screen so we get this presentation underway. Hopefully I do it right. Here we go. Share. Okay, everybody up. How do I move it over? Well, there we go. There's me. Sorry about that. Okay, so service animals in your association. We'll get right down to business here. Service animals, and there's me. A little bit of background. Sorry, a little bit of background here. I did join the firm in 1998. I'm in my, I think, 23rd year with the firm. I'm a board certified condominium and homeowners association attorney. I have only ever represented condominiums and homeowners since I have been with the firm, and I do handle all types of general association matters as well as litigation. All right, important distinctions. I want to make sure all this stuff is off the top of the screen. Hold on. Okay. Well, all right. Sorry, I'm not that great at screen sharing yet. So just bear with me. Okay, important distinctions. Look, what is an ESA? What is an emotional support animal? Probably the most frequent accommodation request that we see in associations is for emotional support animals. So these are just some distinctions, right, between pets, emotional support animals, and service animals. Pets, as we know, are my household, my dog, my dog George, Stephanie's dog Teddy, and your dogs that aren't trained for any purpose, that aren't trained as service animals, and they're not designated as emotional support animals. They are domestic animals that are kept for companionship or pleasure, and they are subject to pet restrictions. Our pets, if you're in an association that has pet restrictions, any pet rules that require fees or tags or vests or specific walking areas or picking up after the dog, all of those rules apply to our pets. Our emotional support animals are not specifically trained for any particular task, but they do provide assistance or therapeutic emotional support to a person with a disability. According to the HUD and the U.S. Department of Housing and Urban Development, emotional support animals are not subject to an association's pet restrictions, but they are subject to reasonable limitations regarding access. So what that means is they would not be subject to rules such that limit breed or size, but they are subject to rules that apply to nuisance, barking, being on a leash, etc. Service animals are dogs or animals that are individually trained to perform work or tasks for a person with a disability. And the task that the animal is trained to do must be related to the person's disability. And we're going to get into disability and the definitions of all that in a couple of slides. Service animals are not subject to association pet restrictions. And if training is readily apparent, they might not require a request for accommodation. For instance, readily apparent means when you see the service animal and the person or its handler, you know that there is a disability. For instance, a seeing eye dog, or a guide dog, or a dog that is walking with a person in a wheelchair. So if the training is readily apparent, then the resident who's got the dog might not require a request for an accommodation. No fees can be charged. So no fees can be charged for emotional support or service animals. For instance, if your association requires a $100 pet deposit, whenever there's an application or a pet, any pet, that $100 fee cannot be charged to the person who's requesting the ESA or the service animal. They can be charged to the regular pet, but they cannot be charged to the service or ESA. Tenants can be charged deposits or for damages if the ESA causes any damage to the association's common areas. All right. One of the questions that I get a lot is what types of animals are service animals? So one of the things, one of the things we're going to be talking about today is that in 2020, while we were all dealing with COVID, Governor DeSantis signed into law a change to Chapter 760, Florida statutes, which is the Florida Fair Housing Act, and the U.S. Department of Housing and Urban Development issued FHEO 2020-01, was issued on January 28, 2020, and it has to do with assessing a person's request to have an animal as a reasonable accommodation under the Fair Housing Act. And it has a lot of good information, but one of the best parts of the HUD guidelines, and that's what I'll refer to them as, is basically a qualifier as to what animals actually constitute an ESA. And the answer is any animals that are commonly kept in the household, which basically if the animal is a dog, cat, fish, rabbit, hamster, turtle, or other small domesticated animal that is traditionally kept in the household, that is considered an ESA. And it specifically says, for purposes of this assessment, reptiles other than turtles, barnyard animals, monkeys, kangaroos, and other non-domesticated animals are not considered common household animals. So we're going to get into in a couple of slides, what do you do if somebody is asking for the unique animal, the accommodation, because we've all seen the accommodation for, the 6-foot rattlesnake or, crazy stuff like that. And what are the questions that we have to ask? All right, so I mentioned briefly, and I see that somebody raised their hand. If you've got a question, you can type it into the Q&A and I will try to get to that at the end of the slide presentation. So the Fair Housing Act, there's two of them that we follow, right? There's a Federal Fair Housing Act, which is the one that's referenced on your screen, and there's the Florida Fair Housing Act. So we refer to them as the FHA and the FFHA. And basically, under the Fair Housing Act, it is unlawful for a housing provider to refuse to make a reasonable accommodation in its rules, policies, practices, and procedures to a person with a disability who is requesting that accommodation. Okay, so what does that mean? first of all, disability. What is the definition of a disability? A disability is a physical or mental impairment which substantially limits one or more of a person's major life activities. So if a person is considered disabled, if they have a physical or mental impairment which substantially limits a major life activity. Physical or mental impairment, just to give you a physical or mental impairment, can be any physiological disorder or condition, anatomical loss, cardiovascular, reproductive, any skin, endocrine, cosmetic disfigurement. Those are physiological disorders. They can be physical disorders. Mental and psychological disorders, such as mental illness or specific learning disabilities. Physical impairments can be, sometimes they're open and obvious, sometimes they're not, such as speech and hearing, epilepsy, heart disease, diabetes, cancer, HIV and AIDS, multiple sclerosis, arthritis, any of these things that can be considered physical impairments. And then mental capacity, when we're talking about mental impairment, may include such things as depression, panic disorder, obsessive compulsive disorder, autism, anxiety, stress-related issues, post-traumatic stress disorder, learning disabilities, ADHD, and ADD, okay? So if we're talking about a disability, a person who has a disability, we've talked about the disability, and it affects a major life activity. Major life activities there's laundry list of them, and sometimes we don't think of them as major life activities, but they are. Functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, sleeping, concentrating, and working are all major life activities. So caring for oneself, so basically, we have if the person has a disability and it affects a major life activity, and now they're requesting an accommodation, and that accommodation that we're talking about today would be this emotional support animal or a service animal, and that emotional support animal or service animal is necessary in order for that person to be able to use and enjoy the dwelling, just like everybody else. One thing I did want to mention, because it's come up in the past, disability does not include current use or addiction to illegal or controlled substances. Somebody that's a recovering drug user or a recovering alcoholic, that is considered a disability, but somebody who just is using, that is not considered a disability. All right, so the statute basically provides, right, that it's a refusal to grant this accommodation request to a person with a disability who needs the accommodation in order to use and enjoy the dwelling. So discrimination, we have two types. We have reasonable accommodations and we have reasonable modifications, all right? Reasonable modifications, very quickly, are refusal to allow a person with a disability to make a reasonable modification of the existing premises at their expense, where it's reasonable to do so, as long as the person either is going to pay for it or they're going to restore the property at the end of their use. But a reasonable accommodation is what we've been talking about, and that is a refusal to make a reasonable accommodation in rules, practices, policies, or services when they may be necessary to afford such a person equal opportunity to use and enjoy a dwelling. All right, so in what I do with my association clients, I frequently get questions like, we're a no pet building, and or we're a no pet association, and now we've got this application. Or we've got this person who's coming with this dog and they're claiming that it's an emotional support dog. And I've now, like, over the years, because it's become more and more frequent, there's basically no such thing as a no pet building or a no pet community anymore. I'm sure most of you can, if you're here, you probably get that. So one of the things we have to consider being an association practitioner is liability, because, and over the years, I will say that clients and association boards have become more understanding of the process, but for many, many years, boards, if somebody came in with a request for an emotional support animal, basically they, maybe they had a hard time understanding what it was or what it was for, because the person didn't have to have the dog with them at all times. So that's a little different than with a service animal. And so, they said they always wanted to deny the request. And what we had to counsel associations for is that if you just deny the request without going through this interactive process of asking some questions, and we're going to get into those, then you could be subject, association, and potentially your directors, depending on what is said, to a claim of discrimination. And that is important to understand, because a claim of discrimination carries with it attorney's fees. So if an association receives a request and they automatically just deny the request without any interactive process, and that requesting resident turns around and goes on, I'm here in West Palm Beach in Palm Beach County, but if they were to go to the Palm Beach County Office of Equal Opportunity, which is the intake place for discrimination claims here in Palm Beach County, and say, my association won't let me have my dog, I requested that they allow me to have the dog, it's over the weight limit, or it's a no dog building, and they just flat out told me I couldn't have it, that investigating officer would open an investigation. They would require the association to provide responses as to what type of operation it is and what they did, what the association did when they were in response to the resident's request. And at the end of the day, if the association couldn't defend its position because it had just said no, then the investigator would make a finding that a discrimination has occurred. Well, when the investigator makes a finding that a discrimination has occurred, then that gives the resident grounds to file a complaint in federal court. And a complaint for discrimination in federal court is a big deal. I mean, it's a big deal in state court, but it's a big and much more expensive deal in federal court. So what we try to do is always counsel our clients on how, if a person is going to bring a claim for discrimination, what, a failure and failure to, for a discrimination for failure to make a reasonable accommodation, what are the elements, right? And association, what do you need to know in terms of those elements that we didn't respond to? So the 4 elements for a prima facie case establishing discrimination based on a failure to provide a reasonable accommodation are: 1, the complainant suffers from a disability. We talked about what those disabilities are. And the respondent, that would be the association, knew of the complainant's handicap or should reasonably be expected to know of it. So reasonably be expected to know of it if it's an open and obvious disability, as in I'm blind and I have a seeing eye dog, that would be an open and obvious. Or if they knew of the disability. If they knew of the disability, that's because either the requesting resident provided documentation, or maybe they sent an email and said, I have PTSD, or I have, they may or may not have said what it is, but I have a disability, I need this accommodation. If the accommodation of the disability is necessary to afford the complainant an equal opportunity to use and enjoy the dwelling, how does the animal or the ESA or the service animal relate to the disability. When we're talking about a service animal, that's easier because the service animal is specifically trained to perform tasks related to the disability, right? So we have seeing eye dogs, we have dogs that alert their owners to when they're going to have perhaps an epileptic seizure or their blood sugar is low. We have dogs that are trained to open doors and turn on lights. So those are dogs that are specifically trained for the disability. If somebody though has PTSD or anxiety or stress, which fall under those disability categories that I related to you earlier, an emotional support animal might be there to ameliorate the stress or the anxiety. Okay, so the accommodation of the disability is necessary, right, to afford the complainant an opportunity to use and enjoy the dwelling. I need the ESA, right, because it relieves my stress and anxiety, and so therefore I can use and enjoy my dwelling like everybody else. That such accommodation is reasonable. So in this case, we're talking about pets and we're talking about accommodations of perhaps the no pet rule. So would it be reasonable or unreasonable for an association to deny somebody the right to have the ESA, or would it be reasonable or unreasonable to disallow the accommodation? And then the respondent refused to make the accommodation. So if the association just says no to the request for the accommodation, when I give board member certification seminars, they talk about all these operations of associations, and I think the very last slide has to do with service animals and emotional support animals. And the one thing I say all the time is don't just say no. Always engage in the interactive process. And I think down here is what I said earlier, the FHA complaints concerning denial of reasonable accommodations and disability access comprise almost 60% of all FHA complaints, and those involving requests for reasonable accommodations for assistance animals are significantly increasing. And I don't think that comes as a surprise to anybody. All right, so section 760.27 Florida statutes, that was the new portion of the Florida Fair Housing Act that became effective July 1st, 2020. And the new law prohibits discrimination by housing providers against someone requesting or requiring an ESA, but it also provides penalties for providing false or fraudulent proof of the need for an ESA. All right, I wanted to read sometimes I just like to read the portions of the statute. So providing false or fraudulent proof of the need for the ESA. So 760.27, makes it a misdemeanor, but the legislature also added section 817.265 Florida statute. That was created last year, and that is entitled false or fraudulent proof of need for an emotional support animal. Okay, so what they've now done is said a violation of 760.27 is now a second-degree misdemeanor and is cited under 817.265, which states a person who falsifies information or written documentation or knowingly provides fraudulent information or written documentation for an emotional support animal under section 760.27, or otherwise knowingly and willfully misrepresents himself or herself through his or her conduct or through a verbal or written notice as having a disability or disability-related need for an emotional support animal, or being otherwise qualified to use an emotional support animal, commits a misdemeanor of the second degree, punishable as provided in section 775.082 or 083. In addition, within 6 months after a conviction under this section, a person must perform 30 hours of community service for an organization that serves persons with disabilities or for another entity or organization that the court determines is appropriate. So what probably many of you who are on this seminar know is that before this law was enacted, we were getting a ton of fraudulent claims for emotional support animals. And most of the time, the request for the emotional support animal would come with a tag from an internet-based company, right? A tag from an internet-based company that said, my dog is an ESA, a trained ESA, right? That should have been our first clue that there was something wrong with it, even though I think most of us knew that there was probably something wrong with just getting a tag from an internet provider saying that our dog is a trained emotional support animal, right? Because we know that they're not trained, emotional support animals aren't trained. And it was just a certificate, because the real question, right, is not if the dog is an emotional support animal or now an official or a certified emotional support animal. The issue is the person disabled, and do they require that emotional support animal, right? My dog George, if I had a disability, my dog George, and my doctor prescribed it, who has no training whatsoever, the only thing he can do is sit for treats, could be my emotional support animal if I had a disability and my doctor prescribed him for that disability. Okay, so falsifying or knowingly providing fraudulent information or documentation, knowingly or willfully misrepresenting oneself as having a disability or disability-related need for an ESA, and for healthcare practitioners, providing information regarding a person's disability without having personal knowledge of the person's disability or related needs. All are penalties now under 817.265. All right, so these were the changes that we were talking about. So healthcare provider, so this is under 760.27 Florida statute. So this is the law that went into effect last July, and we've kind of been working with for the last year. And, where we used to, so my clients are condominium and homeowners associations, and where my clients used to request that I provide them with a reasonable accommodation request verification form when they received a request for an accommodation, and they would make that a part of their package. Sometimes they would make it a part of their application, for lease or application for purchase. I have some clients that would make it a part of the package. Other clients who would just keep it on hand if the need arose. But they would make that document a part of the process and require it. Well, this new statute basically says that the housing provider or association, while we can develop a process to review the ESA request, and we can request reliable supporting documentation, we cannot require the use of specific forms. And we also cannot require that a doctor attest, right, or sign with a notary. That we cannot require the attestation by the doctor. Maybe we ask for a letter from the doctor, or the doctor's signature, but we can't require that they sign under oath. So it doesn't mean that we can no longer utilize a form. What that means is that we cannot deny a request if the owner of the dog or the animal or their physician doesn't fill out our form, and they use some other documentation, or they provide some other documentation, right? So while we can't require specific forms, we can still utilize the form. It kind of just, it is a roadmap, right? It's a guide basically for being able to establish the need for the disability. It still requires the doctor to sign off on the fact that the person has a disability. Obviously, the form cannot ask for information that discloses the diagnosis. It just asks if there is a disability. And associations, you can ask if there is a disability, but you cannot ask what the disability is. We can also ask what activity the animal performs, or how the assistance animal is related to the disability. What does it do for the disability that will enable the resident to use and occupy the dwelling like everybody else? With regard to healthcare providers, and let me go back and talk about if the disability is not readily apparent. The association can request reliable information that reasonably supports that the person has a disability. And I think I talked about it earlier. And a determination, so this is the new statute, a determination of disability from any federal, state, or local government agency. So if the person is receiving disability benefits, that is a determination that there's a disability, and there's no request, it is not necessary to get any additional information, because that regarding or supporting the fact that the person has a disability. Proof of eligibility for housing assistance or a housing voucher received because of a disability, or information from a healthcare practitioner. And this is the one that I think we deal with the most, because we have the most questions and about, a lot of times we have questions about, or my clients have questions about the authenticity of the letters that they receive now, right? Because I think we know that the certificate saying that the doggy is an ESA is not good enough. So now we're getting letters from physicians or physician's assistants or healthcare practitioners that are stating that the residents have a disability. And what the statute says is that reliable information that supports a disability is information from a healthcare practitioner, a telehealth provider, or any other similarly licensed or certified practitioner in good standing with his or her profession's regulatory body, even in another state, but only if they're out of state, only if that practitioner has provided in-person care to the tenant or resident or requester on at least one occasion. Okay, such information is reliable if the practitioner or provider has personal knowledge of the person's disability and is acting within the scope of his or her practice to provide the supporting information. So if the support animal, the need for the support animal is not readily apparent, the association can request reliable information that reasonably supports the person's need for the emotional support animal. And that information may include information identifying, so this is with regard to the pet itself, information identifying the particular assistance or therapeutic emotional support provided by the specific animal from a healthcare practitioner or any other similarly licensed or certified practitioner in good standing. Okay, so the pet itself, the reference to the pet itself should be in the information that comes from the healthcare provider. So the healthcare provider has to have personal knowledge, and the new statute does create a new cause for disciplinary action against the healthcare practitioner's license if they provide documentation for an ESA without personal knowledge of their patient. And again, we just went through what the patient has to provide. If the disability is not apparent, they must provide the housing provider, that would be the association, with supporting documentation from a licensed healthcare practitioner. They are liable for any damage caused by the ESA. So again, we talk about, if the dog, I've had a lot of emotional support animals that do their business in the hallways, meaning they pee and they poop in the hallways, and the association has to steam clean or clean up. So certainly the owner of the ESA is responsible for those damages that happen in the common areas and subject to that second-degree misdemeanor. All right, what can we ask, right? So this is always, again, I might sound like I'm repeating myself a little bit here, but I do think that a lot of these things are important, and this is always what I get asked. What can I ask? What can't I ask, right? So does the person seeking to keep the animal have a disability? We're not asking what the disability is, right? but we can say, is there a disability, right? Is there a physical or mental impairment that substantially limits one or more major life activities? We talked about that at the beginning, right? Is the animal required because of the disability? Has the animal been trained to perform a specific task? Or how does, put another way, how does the animal provide the assistance to the person with the disability? The second question is more difficult, but asks whether, right, basically, what does the animal do for you? So again, we cannot ask what the disability is, but we are entitled to know if there's a disability, is the animal required because of the disability, and what does the animal do to provide assistance or ameliorate the disability? Okay. So under the new provision of 760.27, emotional support animal registrations, and I think I went over this at the beginning, registrations, any cards, patch, certificate, or similar registration obtained from the internet is not by itself sufficient information to reliably establish that a person has a disability or disability-related need for an emotional support animal. The key question is whether the documentation presented is reliable, okay? Right, so when we get that certificate from the internet, it's just a certificate that says that the dog is an emotional support animal. It doesn't say anything about my disability or my disability-related need or how that animal provides assistance to me. So before denying a reasonable accommodation request due to lack of information confirming the individual's disability or disability-related need, the association should engage, right, in that dialogue called the interactive process. So that's what I was talking about earlier. We don't just want to say no. I represent some communities that are, there's signs at the front of the communities that say we are a no pet community. And there are more dogs in there than in any other location because there are so many emotional support animals. And, again, as long as the board doesn't automatically say no when they receive one of these requests, then that investigator that we talked about a few minutes ago, who's investigating a claim for discrimination, is not going to find that there's been a discrimination. One key component to this claim for discrimination that everybody should be aware of is that there actually has to be a request from the resident who has the emotional support or service animal, all right? Just because a resident shows up with, their new dog that may be an ESA or a service animal, and now they're claiming that it's an ESA or a service animal, doesn't mean that they've made a request to the association for the accommodation. So a lot of times what happens, I know with my clients, has happened in the past, it's a no pet community, or maybe pets are allowed, but there's certain breeds that are disallowed, or there are size limitations on those pets. And we used to call them, 23 years ago when I started practicing, we called them the fat dog cases, okay? And because there were limitations on the size of the pet, no more than 20 or 25 pounds, and then we'd have a 50-pound dog. Well, now the 50-pound dog is an emotional support animal. So we don't call them fat dog cases anymore. They're emotional support cases. So what would happen is the resident shows up with a dog where, in violation of the rules, whatever the rule may be, and the association says, Laura, send a demand letter. And so we do. And we send a demand letter saying your dog is, your German Shepherd dog is clearly over the 20-pound weight restriction. You need to remove the dog. That would be the standard letter that would come out for, a fat dog issue back when. And now, and what would happen is that, if that person would claim, well, this is my emotional support animal, or this is my service animal, if they didn't come back to the association and say that, and it's happened, they would go right to the Palm Beach County OEO and make a claim for discrimination and say, I got this letter from my association that says, you know, I need to remove my dog, but it's an ESA. And in that investigation, it would be determined, in the example I'm giving you, it would be determined that, well, the person had never requested an accommodation from the association. And that is a key component, right, to discrimination. So if they've never asked for the accommodation, I can't deny them the accommodation. So, but as soon as they request it, whether it can be verbally, you know, if once they say, well, I talked to the manager or I talked to the president, you know, the association can be on notice at that point. So once they've made the request, then the association has the obligation, in my opinion, to avoid a claim for discrimination, to engage in this interactive process of making a determination as to whether a person has a disability and whether there's a need for the accommodation and how the dog or animal affects the need. When can we say no? So, right, we've got somebody requesting the accommodation and we want to say no. I can tell you that I know in Miami-Dade County, there is an ordinance on the books that says pit bulls as a breed are prohibited in Miami-Dade County. And just because the Miami-Dade ordinance says that pit bulls as a breed are prohibited in our county doesn't mean that the association can automatically deny a request for an accommodation of a pit bull breed dog, okay? So because the breed specifics, the federal government and the FHA, doesn't matter what the breed is. If the dog is providing assistance to somebody with a disability, doesn't matter what the breed is. We know this because our clients have tried to deny accommodation requests for those types of breeds. And there is now case law that says we can't deny based on the type of breed of the animal. But when can we say no? If the specific animal in question poses a direct threat to the health or safety of others that cannot be reduced or eliminated by another reasonable accommodation. I had a case where a dog was lunging at other residents in the building. The owner of the dog couldn't control it, even when it was on a leash. I've had cases where the dogs have bit other people and we've had to ask for their removal. So, and you know, typically those aren't the dogs that are trained as service animals, they're the emotional support animals. And so if they're creating a nuisance, if they're not trained, if they're, again, lunging and biting, I mean, that's posing a threat to other residents, so they can be asked to be removed. You know, we have the emotional support animal that every time the person goes off to work, because emotional support animals don't stay with their owners all day long. And they're not required to stay with their animals all day long, the way somebody with a service animal probably or does need their animal to stay with them all day long. But emotional support animals don't stay with their handlers all day long. And a lot of times what happens, they're home, they're sitting on the back of the sofa, right in that picture window that leads out to the sidewalk or whatever it is, or the common element, you know, area. And every time somebody walks by, they're barking their head off. Happens all the time. We can require that barking, that the resident take action to reduce or eliminate the barking. And if they can't control it, you can ask that the animal be removed. So they have to, you know, they can't become a nuisance to the residents, to other residents or neighbors. So, and if the specific assistance animal in question would cause substantial physical damage to the property of others that cannot be reduced or eliminated by another reasonable accommodation. So, are they destroying property? I mean, have they urinated and defecated all through the carpets in the hallways? You know, definitely requires an individualized assessment. So when we can say no. All right, so basically I'll go through these frequently asked questions, and there they are. This is our list of basically what the frequently asked questions are. And one of the questions that we received when you all were signing up, and I'll deal with this one first, was how come airlines have been able to limit or prohibit or preclude ESAs from flying different than associations. But basically, ESAs are technically still allowed to travel as pets rather than under the service animal category. And the big change is that travelers still have to abide by the rules of the airline in regard to pet travel. So if they have weight restrictions, then the pets have to comply. They've got to pay whatever fees are necessary. And so service animals that treat psychiatric conditions must be trained and provide some sort of service to their owner, as opposed to an emotional support animal. Like a comfort dog is not sufficient. So, and passengers bringing a service animal in tow must still fill out Department of Transportation forms attesting to the animal's training. So I think that was a question that came up that we wanted to look into so we could answer it. But basically, I think some of these questions cover maybe some of, if I skipped over or missed some things here, but can a person have more than one ESA? The answer is yes, but each must be approved and by the association the person must prove that each one is necessary or provides necessary assistance for the person. What kinds of pets are considered ESAs? We did go through that. Common household animals are considered ESAs. I do believe that potbelly pigs are considered ESAs because people do have them as common household pets. But again, reptiles other than turtles are not ESAs. So big fat snakes, ostriches, what do we have? Turkeys, monkeys, kangaroos, not ESAs. What can be done if an ESA is a nuisance? I just explained that to you on the last slide. We could certainly send a demand letter. What about if the association has restrictions such as weight limits? Does the ESA surpass them, have to be approved? Yes, weight restrictions are one of those rules and regulations that does not apply to an ESA or a service animal. This is a good question, the next one. If I purposely move to a no pet community because I am allergic to dogs, why is my association allowing them? And that's a really good question. We had a really sad case many, many years ago because there was an individual in the condominium who required a service animal or an emotional support animal. And she was doing her pet's laundry in the common area laundry facilities. And there were other owners that were very upset by that because they claimed they were allergic. And, I mean, imagine the position, right, that the association is in, because they're required to make the accommodation for the person who needs the dog, because that person has rights under the FHA. So that's why, your association is allowing them. But what does the association do for the person who is allergic to that same pet dander or whatever? So the association has to try to reconcile that issue. And whether it's, using other laundry facilities by the person with the allergy, it's, the HUD and the Palm Beach County OEO will always encourage association and residents to talk about it and to see if there are compromises and workarounds to these issues, because we have to accommodate everybody. We're accommodating the disabled person who requires the ESA, and we need to address the person who has the disability, especially if they need to use, if there's only common area laundry facilities, for instance. We talked about the consequences of denying an emotional support animal if the board thinks the resident is lying about the need for the animal. The association can certainly ask for more disability-related information, but if they receive that disability-related information and then the board still denies the accommodation request, then that individual can bring a claim for discrimination against the association. So my recommendation, because these claims for discrimination are very expensive, and while the association may have insurance to defend it in the case of a claim that is brought, and a claim, I mean a lawsuit, the damages, if there's a monetary award for damages, they could be in the hundreds of thousands of dollars, plus attorney's fees. Your specific insurance policy may or may not cover the actual damages if there's a judgment amount or a settlement amount. They may or may not cover it. So associations who are found to have discriminated against persons requesting ESAs certainly could be subject to large damages awards that, if not paid by your insurance carriers associations, are going to be paid from your unit owner assessments. Can you require a resident to re-qualify for an ESA? Yes, some disabilities are only temporary. One of the questions that we ask is your disability permanent or temporary? And if it's temporary, how temporary? And if it is temporary, then yes, you can ask the person to re-qualify for their ESA. Should the association include the ESA request process during the sales and lease stage? That's to be determined by individual boards. Again, the community that I was talking about a little while ago that says right at the guard gate as you pull in, this is a no pet community, happens to be an over 55 community, and there are more dogs in there than in any other condominium I've ever seen. So that's, they're the ones that they just go ahead and they include the ESA request paperwork in their sales and leasing applications. It's just easier that way for them. But again, that's, dependent on your association. How can a board verify a doctor's note? Can they contact a medical professional? You can verify licenses. All of these physicians that are sending in notes, usually there is a license number somewhere on the paper or under the signature line. So you can certainly verify a physician's license status with their state. And you can try to contact the medical professional, but they're not required to speak with you. Can an ESA be left at home? Yep, I answered that. They can be left at home, and no, they must not be with the owner at all times. Can a guest bring an animal to a no pet community? I would say that if it's just an animal, if it's just a pet, that would be a no. If it's an emotional support animal, that would be a no. If it's a service animal, that would be a yes. They can, a guest that requires a service animal can bring that animal to the no pet community. Can rules be put in place to limit a service animal or ESA from accessing the common areas? Yes, no, sorry. The ESA, no, they cannot be put in place to limit them from the common areas. Sorry about that. The service animals in ESAs service animals cannot be limited. ESAs cannot be limited, but we can, if there's a rule requiring that you walk your dog, you walk your ESA in a certain area and you have to pick up after you've got to pick up after the dog. Those types of rules are enforceable for ESAs, not enforceable for service animals. So unfortunately, if somebody can't bend down and use their hands to pick up, then, because they're disabled, then association, we've got to deal with it, okay? Can the association require annual proof of vaccination? Yes, they can. Under the new provision under 760.27, the association can absolutely require proof of vaccination of the pets on an annual basis. Can an ESA or service animal be prohibited from using an occupied elevator unless they receive consent from the individual riding in the elevator? That would be no. That is common courtesy. However, if there's somebody, who's afraid of dogs, even if you've got the best trained animal, if there's somebody who's, afraid of dogs, I think that's just common courtesy. But the association can't establish a rule saying that they cannot use a certain elevator. unless there's consent. Although the association cannot require a specific form, is there a minimum amount of information that you can require regarding the need for accommodation? Yeah, like we discussed, you can ask about the disability. You can ask if there is a disability and how the animal, what the animal does to affect the disability or ameliorate the disability. Will telehealth consultations be considered in-person care? Not if the telehealth provider is out of state. Under Florida's law, for out-of-state practitioners, the out-of-state practitioner must have provided in-person care or services to the tenant on at least one occasion. So if I read that language very specifically, I would say that nope, the telehealth provider who is out of state must have provided in-person care. Telehealth provider, physician who's here in the state, perfectly fine. And can an ESA request be made after the animal is brought on the property? Yes, it can. Just because somebody brings the dog onto the property first without asking for the accommodation doesn't mean that the association can automatically deny that request. Let me see if any of the questions that I got over here are different. All right, can an association charge for cleaning up of an EMS dog shedding? If that is damages, I don't know how that's damages to the association property. If you were cleaning, I would say probably no. What is this answered question? Okay. Can ESA be restricted to relieving themselves in designated areas that pets go? Yes. If a building restricts pets from being in the lobby, can ESAs be restricted as well unless the owner requests a reasonable accommodation? So once the owner has the reasonable accommodation for the ESA, then the building cannot, oh, the questions are moving now. Then I don't know where the question went. Okay, so once the accommodation request has been provided for the ESA, then the association cannot limit the dog from walking through the lobby. I know that because I had that case 20 years ago, probably. And it was found to be, we had a client association that required that the dogs, if they were going to be walked through the lobby, they had to be picked up. And this resident had back issues and she could not pick up the dog. And so the association said, well, then you need to pull her in a carrier, pull the doggy in a carrier. And so she brought a discrimination complaint and the association lost. So anyways, we can't limit them from the locations that they are walking. Is a medical provider required to be licensed in the state of the applicant? No, but they must have provided in-person care on at least one occasion if they're going to be the one supplying the doctor's note. People are going to websites and assigned to a medical provider who writes the letter. What do we do with that? It's all done through a website. Well, on the website, I guess on the letter that you're receiving, I haven't seen any of those. I know that actually was happening in the past. But if they have to have personal knowledge of the person's disability and their disability related need for the dog. If they are an out-of-state provider, then they would be lying, right? If they said that they had provided in-person services to the applicant, unless they have a website that's here, in Florida. Okay, I'm trying the questions are moving again. What if they were denied because of weight after filling out pet application, but not providing ESA information, then claiming getting a letter from the doctor after the initial application? So just because, so again, I think we talked about, when I sent that letter, right, to the overweight pet owner, and they never told me that the dog was an ESA, the association wouldn't be found to have discriminated. But if the owner then says, but it is an ESA, well, then the association needs to go through that interactive process. And if they then provide the association with the doctor letter, even after the initial application, the association needs to review it and review it carefully, because, you know, on the one hand, while 760.27 does provide, you know, that fraudulent claims are punishable, right, as second demeanor misdemeanors, it still requires the association to review the request and make that good faith effort to, you know, respond to the request. So we have to do, as association practitioners and as managers and board members, we have to do our due diligence to make sure we're not dealing with a fraudulent request. You know, but we do have to consider all those requests. So anyhow, I think our time is up. It's 12:02. Thank you very much for attending today's webinar. I hope that we've gotten some clarification on the laws and the Fair Housing Act and what to do and really what not to do, because that's where I'm focused on, what, you know, what not to do. But if you have any questions, you can submit them to Stephanie and we'll try and answer them. Again, anybody who did attend today's presentation, we will be sending you the PowerPoint that was used today, and everybody stay safe. We'll get through this COVID stuff. And so thank you very much.